Mr. Johnson has requested this appeal in dispute of a $4,000 fine he received on the 8th of December last year for carrying out work at Poseidon Primary School in breach of Section 7 of the Vaccine Order. Mr. Johnson claims that the premise on which the fine was issued was a breach of his Section 11 right to refuse medical treatment under the New Zealand Bill of Rights Act and is therefore unlawful. Counsel, are you ready to proceed?
Defence ready, Your Honour. Crown ready, Your Honour.
Counsel for the defence, you may begin.
Your Honour, this appeal responds to a deep and uncomfortable reality. It's a reality that we as a society keep doing everything we possibly can to avoid. That reality is the reality of uncertainty. The Crown will try and paint this case as a battle between what is right and wrong, between what it means to be a good New Zealander and a bad one, between the reckless negligence of one party and the kind and compassionate compliance of another. The Crown will even try and argue that this case is a matter of life and death. This case is not any of those things. This case is not about right and wrong, good citizen versus bad citizen, ignorance versus enlightenment, nor does it bear any proximate relationship with any matters concerning life or death. This case is about facing our fear of a reality that we simply cannot avoid. The reality of uncertainty. A reality so inseparably woven throughout every element of our government's response to the COVID pandemic to date. This is a case about what we know and what we do not, of what we can show and of what we cannot, of what we can therefore lawfully mandate and what we must not. Popular opinion can have no bearing on the rule of law. My client has his reasons for choosing not to be vaccinated. However, only one of those reasons should be of any concern in this court. That reason is that he chooses to engage his Section 11 right to refuse medical treatment, a sacrosanct right enshrined in the New Zealand Bill of Rights Act, which was suddenly and unjustly ripped away from him by a legislature acting as agent for the tyranny of the majority. The defence will prove that the vaccine mandate requiring my client not to carry out work in his chosen field and the fine imposed on him for refusing to comply is completely disproportionate to any threat he poses and is therefore not a justified limitation on his Section 11 right to refuse medical treatment. The Crown is going to call witnesses who will give evidence that my client is an unpopular New Zealander with unpopular opinions, opinions that do not align with the opinions that the Crown prefers New Zealanders to hold. But the court must show no preference to this state-sponsored groupthink. The court must prefer only the rule of law, and all the more pressingly when the rights of an unpopular minority, a minority which my client most certainly belongs, are being unjustly prejudiced. There is no conclusive evidence that my client's unvaccinated status poses a real and material threat to any other person. Yet the Crown is claiming that my client, by insisting he be able to carry out his work in his chosen trade, is an agent of death. The rule of law is a substantive concept. It is not confined to rigid tests and technical analysis. Previous judicial reviews that ruled in favour of the mandate only peered into the supposed lawfulness of the government's decision-making process, while completely ignoring the very issue that should have been the one deciding factor, the actual liability of my client. The Crown, through enforcing the vaccine mandate, is in effect claiming that my client is willfully endangering the lives of others. Is this not akin to an accusation of criminal conduct? Has my client not been effectively already declared guilty of this offence, already incurring severe penalties, a substantial fine, and of an even graver seriousness, a state-enforced penalty that he be forbidden indefinitely from carrying out work in his chosen vocation, a vocation he has invested the best years of his life in forming? Under the rule of law, is he not then in principle entitled to minimum standards of criminal procedure? Should he not be presumed innocent until proven guilty? Yet the Crown's justification for overriding my client's fundamental rights rests entirely on this assumption that my client is guilty. Yet the Crown has never proven any guilt. Since when did we, as a civilized nation under the rule of law, ever impose such severe penalties on any citizen based on a mere assumption of guilt? I need give the court no reminder of the certain regimes in recent history who have conducted themselves in such a way. All civil and criminal proceedings require the accuser to show an unbroken chain of causation between the alleged wrongdoing of the accused and the harm suffered by the victim. If this chain of causation cannot be shown, then there can be no liability. Where then is the unbroken chain of causation between my unvaccinated client and the person or persons whom he is alleged to pose a threat to? But for the actions of my client, who will be dead? Nor has the Crown proven, to the minimum acceptable standard of proof, that my unvaccinated client poses a certain risk of death to others. In a free and democratic society under the rule of law, when has it ever been said that a person is guilty based merely on evidence of a probable contribution to risk? Evidence that barely scrapes in on the balance of probabilities. A murderer could not be convicted on this standard of proof. Should then my client? At the conclusion of this trial, I ask that Your Honour order the fine to be waived and that the vaccine mandate be declared an unjustified limitation on my client's right to refuse medical treatment. I also ask that an order be made his employment as a contractor at the school be reinstated.
Crown Counsel, you may begin.
Mr. Johnson has chosen not to be vaccinated. Despite the overwhelming evidence in support of the benefits of being vaccinated and the risks of not doing so, in a free and democratic society such as New Zealand, Mr. Johnson is entitled to make that decision for himself. What Mr. Johnson has no entitlement to is to demand that his right not to be vaccinated be given preference over the rights of our society's most vulnerable members to not be subject to what is an otherwise very easily avoidable increased risk of death. In the face of clear evidence showing that vaccine mandates materially contribute to reducing the risk of transmission, ultimately saving lives, Mr. Johnson chooses not to be vaccinated. Despite clear evidence that the risk of not being vaccinated far, far outweighs any risk posed by being vaccinated, Mr. Johnson chooses not to do so. Despite the fact that this life-saving vaccine is free and readily available all throughout New Zealand, a privilege not afforded to so many others in the world today, yes, despite even this, Mr. Johnson chooses not to be vaccinated. And that is his right under Section 11 of the New Zealand Bill of Rights Act. However, Section 11 is not the only right contained within the New Zealand Bill of Rights Act. There is also the Section 8 right not to be deprived of life. When faced with the choice of upholding Mr. Johnson's Section 11 right to refuse a vaccine against the Section 8 rights of our society's most vulnerable members to not be deprived of life, our democratically elected leaders did what they are elected to do. They made a decision, and that decision was that the Section 8 right not to be deprived of life must prevail over Mr. Johnson's insistence that it not. The Crown will be calling 3 witnesses. The first witness, Ms. Smart, is a teacher at the school where the offence occurred. Based on her interaction with Mr. Johnson on the day in question, Ms. Smart will give evidence that Mr. Johnson's reliance on his right to refuse medical treatment is not founded on any sincere or conscientious objection to medical treatment, but rather on a litany of lies and a mire of misinformation. Ms. Smart will testify that Mr. Johnson made statements that the virus poses little to no threat, that the vaccine poses a certain risk of death or injury for the majority of those who receive it, and that every single one of our government departments are all working together in conspiracy towards some sort of global agenda led by none other than software developer Mr. William Henry Gates. The second witness, Sergeant Robertson, was the officer who arrested Mr. Johnson on the day the offence occurred. He will give evidence that a search of Mr. Johnson's phone found no evidence of any contract tracing, and that his web browsing history showed an overwhelming preference for discredited news sites with no record of any credible mainstream news sources or online government information sources. The third witness, Dr. Brain, is Chief Epidemiologist for the Chief Science Advisor and has a PhD in virology. She will give evidence that the vaccine Mr. Johnson refuses to take presents no personal risk to him, and that by refusing to take it, he is contributing to the risk of community transmission, putting the lives of other New Zealanders at risk. The Crown will prove that Mr. Johnson's decision not to be vaccinated is reckless, negligent, irrational, and founded not on any sincere or conscientious objection, but on a willing victimhood driven by an insatiable desire for misinformation. The Crown will show that the vaccine mandate is proportionate to the risk posed by Mr. Johnson, is the only reasonable option in managing the risk he presents, and is therefore a completely justified limitation on his Section 11 right. The Crown seeks that the limit on Mr. Johnson's Section 11 right imposed by the mandate be declared justified, and that the fine for his breach be doubled. I now call first witness for the Crown.